The morning light filtered through the tall windows of the Willow Creek Public Library, casting golden beams over decades-old stacks of hardcovers and reference manuals. Margaret Hastings, 51, sat quietly at her usual desk near the archives. Her reading glasses low on her nose, sifting through microfiche reels of local property deeds from the 1800s. To the casual observer, she might have appeared to be researching out of curiosity or indulging a historian's hobby. But to Margaret, this wasn't leisure, it was preparation for war. She tucked a lock of her graying auburn hair behind her ear and reached for her coffee, cold now. The hum of the microfiche machine mixed with the gentle rustling of pages. Around the library. Her mind was elsewhere, the letter. It had arrived 2 weeks earlier, delivered in a thick envelope marked with a firm's gold-embossed logo, Whitman and Riles LLP, a name that suggested money, connections, and polished threats. She hadn't opened it immediately. Something in the envelope's weight had felt ominous. When she finally did tear it open, her heart sank. The document inside, filled with cold legalese, informed her that the land on which her family's now abandoned homestead sat, 18 acres, on the edge of Woodrow County, was slated for a rezoning application. A private developer intended to bulldoze the remnants of the Hastings property to build luxury condos and a golf course. According to the letter, she had 30 days to either consent to a payout for any remaining claim or prepare for legal action to contest her unauthorized occupancy of land the firm now claimed was free of enforceable encumbrance. She read the letter twice, then again. No. This couldn't be. Her great-grandfather's name was on the original land grant from 1891. She had seen it herself in the archives, the same ones she'd been poring over every evening for years, unsure why until now. Perhaps it was intuition. Perhaps it was fear disguised as curiosity. But now, the reason stood clear. She had to fight for what remained of her family's legacy. The next day, Margaret drove out to the old Hastings property. The gravel road was barely more than tire grooves, flanked by tall grass and the faded ghosts of fencing. The house was just a shell now, collapsed on one side, its porch overtaken by vines. But this land, the slope of the hill, the woods where her brother used to trap fireflies, the creek where her mother once washed their clothes, it was sacred. No glass tower or tennis court had the right to erase it. Back at the library, she began building her case. She didn't tell anyone at first, not her neighbor Janet who brought her tomatoes in the summer, nor her cousin Ray who'd always said the land was a lost cause. She didn't have a lawyer. She couldn't afford one. But what she had was time, determination, and access to every legal document filed in the county for the past century. She started with zoning laws, then moved on to property tax filings, water rights, mineral rights, adverse possession cases. She created a timeline. Then a legal strategy. Then a list of precedents. The court date arrived faster than expected. She filed a motion to represent herself, pro se. The clerk behind the counter blinked in surprise, then smiled awkwardly as if to say, "You sure you want to do this?" "Yes," Margaret said simply, sliding the papers forward. "I do." On the day of the hearing, she wore her late mother's navy blue blazer, pressed with care, and a simple gray skirt. She didn't own a briefcase, so she carried a worn leather tote with her documents neatly organized by tabs and color-coded markers. The courtroom felt colder than she expected. Fluorescent lights hummed overhead. The seal of the state loomed. Behind the bench like a silent witness, the developers sat on the opposite side, 3 attorneys in tailored suits, whispering to each other as she entered. One of them, a tall man with slicked back hair and the kind of smile that belonged on campaign posters, raised an eyebrow. "No counsel?" he asked aloud, glancing at her tote bag. Margaret ignored him and took her seat. Then came the judge. Honorable Richard K. Greaves. Late 60s, stern, known for impatience. He scanned the docket, his gaze pausing when he reached her name. "Miss Hastings, you're representing yourself?" "Yes, Your Honor." "I see," he said, a trace of skepticism curling around the words. "Very well. Counsel, you may proceed." The first half-hour was a blur of motions, objections, and legalese. The attorneys from Whitman and Riles presented their case, that the Hastings land, abandoned for over a decade, had reverted under dormant title statutes, that Margaret had failed to pay property taxes, that no active deed named her as rightful owner. They spoke quickly, confidently, as if expecting no serious challenge. Then it was her turn and Margaret stood. Her voice, at first, was quieter than she intended. "Your Honor, I would like to present evidence countering the claim of abandonment." She handed over a thick binder. "Within are property tax receipts paid in my grandfather's name through 2003, when the county began rejecting payments due to clerical discrepancies. I also have photographic and testimonial records showing ongoing maintenance efforts by myself and extended family." The judge glanced at the binder, then at her. "Continue." She did. For 40 minutes, she cited case law, quoted from local ordinances, and drew attention to historical inconsistencies in the developer's timeline. The opposing counsel interrupted once, laughing when she mispronounced a Latin phrase, but the judge silenced him with a sharp look. Then, just as she reached the end, she opened a manila folder marked Final Authority. Your Honor, she said, her voice steady now, I'd like to direct the court's attention to the ruling in Jennings v. Moore County, 1994. It's an obscure but controlling precedent in this jurisdiction. The court found that failure by the county clerk's office to notify family heirs of record before declaring land abandoned constituted a violation of due process. She handed over the case file. The courtroom fell silent. Judge Greaves adjusted his glasses, flipping through the pages. His expression shifted, from dismissive to intrigued, then slowly to something like respect. We'll take a short recess, he said, closing the file. Margaret sat down, exhaling slowly. She didn't smile. Not yet. But in that moment, she no longer felt like an amateur, she felt like a Hastings. Margaret stepped into the courthouse hallway as the heavy doors swung closed behind her. The murmurs from inside faded, replaced by the distant echo of footsteps and the soft hum of fluorescent lights. Her legs trembled as the adrenaline ebbed. But she kept walking, heels clacking steadily down the tile floor until she reached a bench beneath a faded portrait of a retired judge. She sat down slowly, fingers still curled around the edge of her tote bag. She stared ahead, but her thoughts were far from the hallway, back in the courtroom, where Judge Greaves had looked at her not with pity or condescension, but with a flicker of genuine interest. That shift in his eyes, it had felt like a victory. Small, maybe, but real. The door next to her creaked open, and a low voice called out, Miss Hastings? It was Deputy Clerk Mallory, a young woman with a kind face and a clipboard in her hand. Judge Greaves has asked for a 40-minute recess. You're welcome to stay here or step outside, but be back by 11:30. Thank you, Margaret said, rising. Outside, the July air hit her like a wave, warm, heavy with the scent of pavement and cut grass. She found a quiet bench under an elm tree near the courthouse steps. The town of Woodrow passed by around her, a woman pushing a stroller, a UPS driver waving at someone across the street, teenagers drifting toward the coffee shop on Main. Life going on, unaware of the courtroom battle unfolding inside. Her battle. She pulled out her phone and tapped a number she hadn't dialed in months. It rang twice before a voice answered. Ray Hastings. Hey, she said quietly. It's me. There was a pause. Well, I'll be damned. Didn't expect this call. I'm in court. I know. Heard about it. Figured you'd give in and take the payout like the rest of us. I didn't. He exhaled loudly on the other end. Margaret, you sure this is worth it? That land's been rotting for years. There's nothing left. There's history, she said. There's our family. Family doesn't show up when it matters. You're doing this alone. I know, she said. I just thought you should know I'm not backing down. Another pause. Then, good luck. He hung up. Margaret stared at the screen. The ache in her chest wasn't anger, it was sadness. The kind that comes from knowing you're the only one who still sees value in something everyone else has given up on. Back inside, the courtroom was cooler now, quieter. A different energy. The opposing lawyers had returned, flanking their client, Charles Denner, CEO of Denner and West Properties. He was younger than she expected, maybe late 40s, with a silver tie and skin too smooth for someone who claimed to know the land. He glanced at her briefly, then leaned in to whisper something to his counsel. She took her seat, her binder back in front of her, hands clasped tightly in her lap. Judge Greaves returned a few minutes later, his robe trailing as he climbed the steps behind the bench. He didn't speak right away. Instead, he adjusted his glasses, looked down at the folder Margaret had provided, and tapped his pen once, twice, against the desk. I've reviewed the citation from Jennings v. Moore County, he said, his voice measured. It appears that Ms. Hastings has introduced a precedent that may warrant reconsideration of the property's classification. The court acknowledges the merit in the due process violation claim, particularly the absence of adequate notice to surviving heirs prior to the county's abandonment designation. The room was still. The developer's attorney shifted in his seat, his mouth twitching as if to object, but stopped. Margaret held her breath. Therefore, the judge continued, the court will allow an evidentiary hearing before any further motions are granted. Both parties will submit full documentation within 10 business days. In the meantime, I will not authorize any demolition permits or construction activity on the property in question. A restrained gasp escaped from the back of the room. A local reporter, perhaps. Margaret didn't turn. Her eyes were locked on the bench. Court is adjourned for today. The gavel struck. Margaret remained seated as the room began to clear. The developers left quickly, stiff-faced and whispering. Only one of the lawyers looked back at her, the youngest of the group, a woman who hesitated just a moment before nodding slightly. Not in approval, necessarily. But in recognition. Margaret stood outside the courthouse. The town looked the same, cars humming by, flags flapping gently in the breeze. But to her, everything felt different. Not because she had won anything yet. She hadn't. Not officially. But the balance had shifted. She walked to her car, slid into the driver's seat, and placed the binder gently on the passenger side. She wasn't naive. She knew the developers would regroup, dig deeper, look for a counterstrike. But now they knew what she was capable of, and the judge did, too. She started the engine and pulled away from the courthouse, heading not toward home, but toward the edge of Woodrow, toward the land. Her land. The summer sky stretched endlessly above her. The road, though bumpy and cracked, was still there. So was she. Margaret parked the car just beyond the overgrown ditch that once marked the northern boundary of the Hastings property. The tires crunched against gravel and weeds, and the vehicle's engine ticked in protest as it cooled under the hot midday sun. She stepped out slowly, shielding her eyes. The air smelled of dry earth and pine needles, and the faint hum of cicadas filled the silence like static on an old radio. The house, or what was left of it, still stood stubbornly among the trees. Its porch sagged, roof half collapsed. Shards of glass still clung to the kitchen windows. Ivy had claimed most of the back wall. Margaret stood before it, feeling the past weigh on her chest like a stone. She hadn't been back since her father's funeral, nearly 10 years earlier. He'd refused to sell, just like her. "We don't let our dead get paved over," he'd said once. "We remember where they're buried." At the time, she thought he meant it metaphorically. But now, as she walked the narrow footpath behind the house, brushing aside thistles and overgrown grass, she knew he'd meant it literally. The old family cemetery sat behind a rusted wrought iron gate, small and nearly hidden beneath a canopy of trees. 5 headstones stood in a crooked line. Her great-grandparents. Her father's brother, Samuel. Her mother. And finally, a stone with no name, just a year. 1923. She knelt in front of it, brushing away a layer of moss with the sleeve of her jacket. "This is why I'm doing this," she whispered. "They think it's just land. Just dirt and lumber. But it's more than that." She stayed for almost an hour. Not praying, not crying, just remembering. On the drive back into town, she detoured past the county recorder's office. Her steps were firm, deliberate, as she entered the cool building and approached the counter. Behind it sat Gina Tran, a middle-aged clerk with salt-streaked hair and a sharp, no-nonsense tone. Margaret had dealt with her before, years ago, while trying to correct a discrepancy in the tax rolls. Gina had been polite but indifferent, the kind of bureaucrat whose job depended more on procedure than judgment. "I need copies of all notices of abandonment filed on the Hastings land between 1999 and 2006, Margaret said. Gina raised an eyebrow. "You sure that's not already been pulled for the court case?" "Positive. And I need the logbook of certified letters sent to heirs." Gina hesitated. "That's not something we usually release without a subpoena." Margaret pulled a small folder from her tote and slid it across the counter. Inside was a signed directive from Judge Greaves, filed just that morning, authorizing limited discovery access. Gina blinked, took the folder, and nodded. "Give me an hour." Margaret sat in a side room, sipping from a vending machine coffee and staring at the linoleum floor. Her nerves were returning. The courtroom had been an intellectual test, but now came the slow grind of research, of proof. She needed to find something the developers had overlooked. A technicality. A hole in their chain of title. Anything. Gina returned sooner than expected, holding a thin manila envelope. "There's no record," she said flatly. "No proof of certified mail sent to you or any known Hastings heirs before the land was declared abandoned." Margaret's eyebrows lifted. "None? Nothing I can find. And that's irregular. That logbook should be complete." Margaret's mind raced. Could it have been deleted? Gina frowned. "We keep paper records. If someone removed pages, there'd be gaps. I'd have to check the physical binders." "Can I see them?" The clerk hesitated. "I'm not supposed to. I'll sit quietly," Margaret said. "You can supervise the whole time." Something in Gina's expression shifted. Curiosity, maybe. Or guilt. Or a growing sense that this wasn't just a petty land squabble. "All right," she said finally. "Come with me." In the records room, Margaret flipped through bound ledgers the way some people read Bibles, reverently, methodically, with trembling fingers. Hours passed. Dust clung to her cuffs. Her back ached, and then she found at point 2 entries dated 2003. One for a notice mailed to Ray Hastings in Tennessee, and one to a Margaret H. Hastings, care of Willow Creek Public Library. Both marked with asterisks. Neither with a delivery confirmation signature. She stared at them, heart thudding. They had attempted to send notice. But it had failed. And more importantly, the law required proof of delivery. Without it, the Abandonment declaration could be nullified. She photographed the entries, printed copies, and filed them into her evidence folder. As she thanked Gina and made her way back outside, the sun had begun to lower behind the courthouse dome, casting long shadows over the street. She paused on the sidewalk. Across the street stood the office of Denner and West Properties, a sleek glass and brick building recently converted from an old bank. Through the window, she could see Charles Denner sitting at a desk, speaking on the phone, gesturing with a pen. He looked confident. Comfortable. She wondered if he had ever walked the Hastings land. If he had stepped into the woods, or touched the cemetery gate. If he'd even bothered to see what he was trying to erase. She doubted it. Back in her car, she scribbled a note in her margin, intent to challenge notice validity, key argument for evidentiary hearing. The case was far from over. The developers would fight with everything they had. They'd find new angles, higher courts, more persuasive language, but now, Margaret had more than just a precedent. She had a paper trail. She had the truth, and she had time. The story broke 2 days later, tucked near the bottom of the Woodrow Weekly Herald, beneath articles about the summer fair and the high school's upcoming football schedule. The headline was modest, but pointed: local librarian challenges developer in land dispute, goes pro se in courtroom showdown. Most would have skimmed past it. But by that afternoon, the article had been shared nearly 100 times on Facebook. A local radio station mentioned it during their community bulletin segment. By sunset, Margaret's phone had rung 6 times, once from the Herald, twice from residents she hadn't spoken to in years, and once, surprisingly, from a law professor at the state university who had stumbled upon the case through a legal blog that picked up the story. It's not every day someone walks into court without a lawyer and pulls off a constitutional argument on due process, the professor said with a laugh. I've got third-year students who couldn't have made that citation. Margaret was flattered, though wary. Public attention was a fickle thing, and she wasn't doing this for headlines. Still, she knew the tide had shifted. What began as a personal stand was starting to feel like something bigger, a story others could rally behind. A challenge. Not just to a developer, but to a system that often treated people like her as disposable. At the library the next morning, the air buzzed with curiosity. Her co-workers, who'd kept a respectful distance since the court hearing, now approached. With cautious admiration, I read the article, said Grace, the circulation manager, handing Margaret a stack of returns. Didn't know you had all that in you. Margaret smiled. Neither did they. She tried to settle into her routine, shelving books and answering patron questions, but her mind kept drifting to the growing folder of case materials in her tote bag. With the evidentiary hearing approaching, she needed to tighten her arguments. Especially now that public attention was involved. She could feel the weight of it, expectation creeping up like a tide. At lunch, she sat in her office. With the door slightly ajar, flipping through a legal pad covered in notes. She had outlined 5 key arguments: lack of proof of certified delivery, historical preservation claims, failure of the county to conduct due diligence in air searches, inconsistencies in Denner's timeline of acquisition. The precedent she had already introduced, Jennings versus Moore County. It was solid, but it needed reinforcing. If they pushed for summary judgment, she'd need to make it airtight. She didn't hear the knock at first. Miss Hastings, came a voice from the doorway. Margaret looked up. A young man stood there, maybe late 20s, with a messenger bag slung over his shoulder and a nervous energy about him. I'm Liam Ross. I'm a third-year law student at UT. I was told you might need help. Pro bono. Margaret blinked. You read the article? He nodded. And the court filing? My professor forwarded it to our legal aid clinic. Honestly, we were impressed. You don't need us, technically, you're holding your own. But if you want some support, research, an extra set of eyes, I'd be happy to help. She considered it. Pride bristled at the offer, but something deeper, something practical, nudged her to listen. You'd be volunteering? Yes, Liam said. And you'd stay in control of the case. Think of me as backup. She gestured to the chair across from her desk. All right, let's talk. Over the next hour, Margaret laid out everything: the timeline, the missing notices, the cemetery, the family history. Liam took notes furiously, nodding, occasionally asking pointed questions. That cemetery could be a pivotal point, he said. If you can establish it as historically significant, and link it to an unbroken chain of familial responsibility, that undercuts the claim of abandonment even further. I have photos. And handwritten maintenance records from 2008. Liam's eyes lit up. That's gold. By the time he left, they had agreed to meet again that weekend to review filings and draft affidavits. Margaret felt a surprising swell of energy. It wasn't just that she had help now. It was that someone young, sharp, and outside the fight, believed in what she was doing. That evening, her neighbor Janet brought over a tray of lasagna and a printout of the Herald article. "You made the paper," she said, beaming. "I'm proud of you." Margaret smiled as she accepted the dish. "Thanks, Janet. I wasn't trying to make headlines." "Well," Janet said, placing the tray on the counter, "you did more than that. You made people look up from their phones for once." Margaret laughed, a genuine, unguarded sound. It had been a long time since she'd felt that kind of warmth, but later, as night fell and the house quieted, she sat at her dining room table, documents spread out in front of her, rereading court transcripts and land records. A different kind of pressure was setting in. They knew who she was now. The town. The media. Maybe even the developers, investors. The narrative was shifting, and narratives could be powerful. But if she lost, it wouldn't just be her land at stake anymore. It would be her credibility. Her story, and stories, she knew as a librarian, were often rewritten by the victors. By Monday morning, the developers struck back. A thick envelope arrived at Margaret's mailbox, this one bearing the seal of the county court. Inside was a motion filed by Denner and West Properties, a formal request to dismiss her claim. The grounds? Failure to demonstrate legal standing and inadequate evidence to override the county's prior abandonment determination. Margaret read the document 3 times, each pass tightening her stomach further. It was a calculated move, a tactic used to rattle, to overwhelm. They were betting that the publicity had inflated her confidence and that now, faced with a cold procedural wall, she'd fold. She didn't. Instead, she called Liam. They met at the library that evening, in the archives room she had long considered her second home. The place was quiet, except for the ticking wall clock and the low murmur of the air conditioner. Liam spread out the motion across a wide oak table, highlighting the language line by line. "They're pushing the burden of proof back on you," he said. Basically saying, even if your claims are interesting, they're not legally sufficient. "They're wrong," Margaret replied. "But I need to show it." Liam nodded. "Okay. Let's get tactical." Over the next 2 hours, they began drafting a formal response, an opposition brief. Margaret dictated her points with remarkable clarity: the unverified abandonment notice, the missing certified mail receipts, the historical importance of the land, the family cemetery, and the new evidence from the county's own logbooks. Liam translated her words into legal language, adding citations, formatting, and structure. "You've basically done the work of a full legal team," he said, glancing at her stack of handwritten notes. "Only slower. And neater." Margaret smirked. "Years in the stacks teach you discipline." Outside, dusk rolled over the town, and the library closed its doors. But inside, they worked late, printing attachments, assembling exhibits, and organizing their argument into 3 pillars: procedural error, factual discrepancy, and constitutional violation. By 10:15 p.m., the brief was ready. Margaret stared at the printed pages in silence. In her hands was more than just paper. It was a rebuttal, not only to the developer's arrogance, but to every voice that had ever told her she wasn't enough. Not powerful enough. Not trained enough. Not male enough. She wasn't foolish enough to think this document would win the case outright, but it would buy her time. It would keep the door open, and maybe, just maybe, it would remind the court that land, memory, and identity couldn't be bulldozed with boilerplate motions. The next morning, she filed the opposition at the county clerk's office. Gina, behind the counter again, gave her a small nod as she timestamped the submission. "Judge Greaves will see this before noon," she said. As Margaret turned to leave, she noticed someone waiting by the exit, tall, well-dressed, and not unfamiliar. It was Charles Denner. He wasn't smiling this time. "Miss Hastings," he said, his voice low and composed. "Quite a media storm you've stirred." Margaret tightened her grip on her tote bag. "I didn't stir anything. I just told the truth." Denner tilted his head slightly. "It's admirable, what you're doing. But you're dragging this out. Public opinion doesn't change the law." "Neither does money," she replied evenly. "At least not in a just court." He gave a short laugh. "You think this is justice? This is leverage. And you're using a family tragedy as a chess piece." That hit like a slap. Margaret stepped closer. "My family buried generations on that land. They built homes with their own hands. It's not a chessboard. It's a graveyard. And I won't let you pave over their names just because you smell profit in the trees." The air between them tensed. Denner's expression changed, not anger, exactly, but calculation. "I can offer you a better deal than the court ever will," he said, voice softer now. "Full payout. Preservation of the cemetery. Your name on the plaque. We'll even donate a portion of the profits to the local historical society." Margaret stared at him. "And in return? You withdraw your claim." She shook her head. "You don't understand. It's not about compensation. It's about legacy. And respect." Denner's jaw tightened. I hope you're ready for what comes next. I've been ready, she said, walking past him and back at the library. She sat alone in her office, staring out the window as rain began to fall, soft, rhythmic, almost cleansing. A summer shower, fast and fleeting. The kind that cooled the ground without soaking it. She found comfort in its timing. Liam texted her a few hours later, filed a motion to oppose the dismissal. Great work today. Let's prep for hearing next. We're on solid ground, she replied with a simple thumbs up emoji, then leaned back and closed her eyes for a moment. Her mind returned to her father's voice, calm and stern, speaking to her one evening as they sat on the porch of the old homestead. Land remembers, Margie. It remembers who walked it, who bled on it, who stood up for it. You don't own it, it owns you. You just get to decide if you're worth the memory. She opened her eyes, the rain had stopped. The streets glistened. And tomorrow, she'd walk back into that courtroom with her evidence, her arguments, and her name, the only tools she'd ever truly needed. The courtroom was quiet when Margaret walked in, early again. Always early. It wasn't nervousness, at least not entirely, but strategy. She wanted the space to settle around her before the heat of arguments began. To breathe it in. To observe. To let the echo of her footsteps remind her that she belonged here, no matter how outmatched the other side tried to make her feel. Liam arrived 5 minutes later, tie crooked, holding 2 coffees, hazelnut. No sugar. Right? She smiled. Right. He handed it to her and sat beside her, flipping open a thin folder. They're pulling in co-counsel today. I saw a name on the docket, Vanessa Klein. She specializes in land reclamation and zoning litigation. Margaret didn't flinch. Then she's probably familiar with Jennings versus Moore County too. Liam smiled. Exactly. Judge Greaves entered shortly after. The room rose. Then, the hearing began. This wasn't the final trial. Not yet. Today was about whether the case could move forward at all, whether Margaret's claim, and the evidence she had built piece by piece, was enough to survive Denner's motion to dismiss. The developers went first. Vanessa Klein was composed, poised, and surgical. She outlined the supposed finality of the county's abandonment ruling, the passage of time, the alleged lack of current ownership documentation in Margaret's name. The petitioner's claim rests on an emotional appeal. She said, her voice calm and precise, but the law cannot bend to sentimentality. The chain of title is broken. The county deemed the land abandoned more than a decade ago. The petitioner is neither listed on the most recent tax rolls nor formally recognized as an heir under state inheritance statutes. Therefore, her standing is insufficient. Margaret listened without blinking. It was an elegant argument. Precise. Cold. Then the judge turned to her. Miss Hastings, your response? She rose slowly, binder in hand. Your Honor, she began, what Miss Klein has outlined is a clean legal theory. But the real world is rarely clean. I'd like to begin with the statute regarding notice to heirs. In 2003, the county was required to provide certified notification before declaring any private land abandoned. I have records, provided by the county clerk's office, showing that notices were prepared, but no proof of delivery was ever obtained. No signatures. No confirmation. She handed over the exhibits. Greaves scanned the pages, frowning slightly. Margaret continued, I've also submitted tax receipts under my grandfather's name, paid through 2003, and evidence of continued familial maintenance on the property through 2008. There are photographs, affidavits, and a letter from a former county employee indicating that the record-keeping system at the time was flawed. If the court needs additional verification, I welcome a site inspection of the cemetery behind the homestead, where 5 members of my family are buried. That caught Klein's attention. Her pen froze mid-note. Margaret went on. This land isn't just a boundary on a map. It contains a legally protected burial site under state preservation law. The developers never disclosed this. They never filed for a historical exemption. They claim abandonment. I claim stewardship. For over 100 years, my family lived, worked, and died there. That matters. Silence followed. Judge Greaves looked over his glasses at Klein. Did your client disclose the existence of a cemetery during the rezoning application? Klein hesitated. To our knowledge, there was no registered burial site. It's registered now, Margaret cut in. I filed the application last week. It's under review by the State Office of Historic Preservation. I've submitted the documentation with today's response. The judge nodded slowly, lips pressed in thought. After a moment, he set down the motion to dismiss. I'm denying the motion, he said, firmly. This matter warrants a full hearing. Ms. Hastings has presented sufficient evidence to question the validity of the county's original process and the developer's due diligence. The historical significance of the land, particularly the cemetery, is now a matter of record. We proceed to trial. He struck the gavel once, with finality, and just like that, it was real. Margaret sat down, heart racing. Liam leaned over, whispering, "You just got everything we asked for." Margaret didn't respond right away. She was staring straight ahead, still absorbing the moment, because for the first time since this began, the court wasn't just listening. It was taking her seriously. That night, she didn't go straight home. She drove instead to the edge of town, to the diner off Route 41 where her mother used to take her for pancakes on Friday mornings. The place hadn't changed much: cracked red booths, a jukebox in the corner that hadn't worked in years, the smell of bacon and stale coffee clinging to the wallpaper. She ordered tea and sat in the far corner, watching people come and go, young couples, tired truckers, retirees. Just people. The kind of people who were rarely heard in courtrooms unless they were on trial or sitting in the back row. The waitress, a woman in her 60s with tired eyes, refilled her cup. "You're that librarian, right? From the paper?" Margaret nodded cautiously. The woman smiled. "My granddaddy's land got swallowed by the highway back in '72. Eminent domain, they called it. Said it'd help the county grow. It did. But not for us." She paused, then added, "Glad someone's fighting back." Margaret felt her throat tighten. "Thank you," she said quietly. Back in her car, she sat for a long while before starting the engine. She thought of her family, those still living and those buried beneath that stubborn patch of ground, and wondered how many stories had been erased by silence. How many names were lost to bad records, bad faith, and bulldozers. Not this one, she thought, not mine. The office of Denner and West Properties stood tall and sleek against the modest skyline of downtown Woodrow, an architectural anomaly of steel and smoked glass, as if a fragment of Manhattan had been misplaced in rural Tennessee. From the outside, it radiated quiet power. Inside, it was colder than it looked. Charles Denner stood at the far end of the conference room, back to the city, arms folded behind him. Floor-to-ceiling windows framed his silhouette as the early morning sun outlined the neat edge of his tailored suit. Behind him, the boardroom table sat empty but for one thick manila folder labeled, "Hastings vs. Denner and West." He didn't like losing. Especially not in court. And certainly not to someone like Margaret Hastings. She just had our motion thrown out, Vanessa Klein said as she entered the room, closing the door behind her. "The judge ordered the case to trial. She has standing. And now she has public sympathy." Charles turned. "I know. She's building momentum. If that cemetery is recognized as historically significant, the rezoning application might collapse entirely. And the land value will plummet." Charles sat, calm and methodical. "We can still settle." Vanessa raised an eyebrow. "We tried." She didn't bite. "She doesn't want money," he murmured, tapping a finger on the folder. "She wants memory. And that makes her dangerous." He opened the file and began flipping through the contents: transcripts, affidavits, media clippings. One page showed a photo of Margaret standing in front of the courthouse steps, chin high, binder in hand. Her posture was resolute. Her eyes defiant. "She's turned herself into a symbol," Vanessa said. "And the press is running with it. Small-town woman takes on corporate machine. People love that." Charles leaned back in his chair. "Then we change the story." Vanessa frowned. "What do you mean?" "We shift the focus," he said. "Dig into her. Her family. Find inconsistencies. Was the land really maintained? Were taxes ever missed? Any legal blemishes? Old debts? Anything that suggests she's not as righteous as she seems." Vanessa hesitated. "That's a dangerous play, Charles. If the press finds out we're running a smear campaign." "It's not a smear," he interrupted. "It's litigation. We're entitled to examine her credibility. And we will." A beat of silence passed between them. "She's not just fighting for herself anymore," Vanessa said. "You've seen the petitions, the local coverage, the calls to preserve the site. You might win in court and still lose in the long run." Denner stood again, moving to the window. "I didn't build this company by worrying about local sentiment. This isn't about one woman. This is about precedent. If she wins, every forgotten acre in the state becomes a potential legal minefield." He turned back to her. "She has resolve. Fine. Let's see what happens when we test it." Across town, Margaret sat at her kitchen table, oblivious to the storm being prepared behind polished glass and boardroom doors. She had just returned from the state archives in Nashville, where she and Liam had unearthed more evidence: a 1964 survey map showing the original property lines of the Hastings land, including notations about burial grounds, fencing, and structures. "This was filed with the state, not the county," Liam had explained. "It might have never made it into the local zoning office's records. That strengthens your claim that the developers didn't do full due diligence." Margaret had photocopied everything, carefully tucking each page into a plastic sleeve. Her binder was starting to look less like a homemade case file and more like a formal litigation brief. She rubbed her temples now, tired but satisfied. A quiet knock interrupted her focus. At the door stood Janet, holding an envelope. "This came for you." "No return address," she said. Margaret took it. The paper was heavier than usual. She opened it slowly. Inside was a single sheet, typed in a sterile serif font. "Before you bury yourself in nostalgia, ask yourself, why did your family let the land rot for a decade? Not everyone forgets so easily." No signature. Margaret stood frozen for a moment, then looked up at Janet, who'd seen her expression. "What is it?" her neighbor asked. Margaret folded the letter and set it aside. "Nothing. Just more noise." But she knew it was more than that. It was a message. Someone was digging. And they wanted her to know. The next day, Liam arrived early for their work session with a strange look on his face. He dropped his bag and sat without speaking for a moment. "Something wrong?" Margaret asked. "I got a call from a reporter this morning," he said. "Asking about your parents. Specifically, whether your father had ever contested the land taxes before his death." Margaret blinked. "He did. Twice. The county told him the payments were misattributed to a neighboring parcel. They said it would be fixed. It never was. They're trying to cast doubt on the timeline," Liam said. "Trying to say the land was abandoned. Willingly. That you're making it more dramatic than it was." She sighed. "Because emotion's the one thing they can't argue with facts. So they'll try to discredit the emotion." "Exactly." They sat in silence for a moment, then Margaret opened a drawer and pulled out a small photograph. It was worn, creased, with a torn corner. A black and white shot of her as a little girl standing in front of the old house, barefoot in the dirt. Her father kneeling beside her, pointing toward the hills. "I'm not pretending the land was perfect," she said. "But it was ours. We kept it alive as long as we could. I won't let them rewrite that." Liam nodded slowly. "Then let's make sure the court hears the real version." That afternoon, Margaret returned to the property. She walked it slowly, taking new photos of the crumbling chimney, the tree where her mother had carved initials, the small wooden cross at the edge of the cemetery that had once marked her cousin's grave. The grass was high. The porch was caving in. The fences had rusted away, but the wind still moved through the trees the same way. And beneath the soil, she could feel their names. Their stories. She stood still for a long time, letting the silence speak. Whatever Denner and his lawyers planned, whatever they tried to find, they couldn't change what the land remembered, and neither would she. The courthouse felt different now. Not colder or warmer, just fuller. As if the air itself had thickened with attention. A week had passed since the judge denied the motion to dismiss, and today marked the official beginning of the trial. Not a preliminary hearing. Not a procedural debate. The trial. Margaret stood at the base of the courthouse steps, binder in hand, as cars passed behind her and a group of 3 local reporters set up a camera just out of sight of the building's entrance. She hadn't asked for any of this, the interviews, the headlines, the attention, but she no longer flinched from it. She hadn't come to be seen. She had come to be heard. Inside, the gallery was fuller than usual. Word had spread, the librarian was going to trial. Some came out of curiosity. Some came because they remembered the Hastings name. Others, former students, neighbors, even a few strangers, came just to sit in quiet solidarity. It wasn't loud support. No signs. No cheers. Just presence. That mattered. Liam met her at the defense table, adjusting his collar nervously. "You all right?" he asked. Margaret nodded. "Ready as I'll ever be." Across the aisle, Charles Denner and Vanessa Klein were deep in conversation, joined by a new face, an associate in his early 30s, tall and expressionless. Margaret didn't need an introduction. The developers were stacking the bench. They weren't taking chances anymore. At precisely 9 a.m., Judge Greaves entered the courtroom. "This is case number 2024, CV 518, Hastings vs. Denner and West Properties. We are here to determine rightful claim over the parcel of land previously declared abandoned by Woodrow County in 2004, currently under proposed development. Plaintiff is representing herself, with pro bono advisory support. Defense is represented by counsel. Let us begin opening statements." Klein stood first. "Your Honor, members of the court," she began, her tone crisp and controlled. "We acknowledge that this is not merely a legal dispute, but one tied to heritage and memory. That said, the law is clear. The property in question was declared legally abandoned following a series of unclaimed tax notices, unmaintained conditions, and a lack of formal heirship on record." She gestured slightly toward Margaret without looking at her. "The plaintiff is not named on any deed. She did not challenge the abandonment at the time. And while her story is compelling, it does not override procedural law. We are confident that the facts will show that our acquisition followed proper channels, and that continued delays will only deprive the community of economic opportunity. The final phrase was deliberate. She was already planting the idea that Margaret stood against progress. Now it was Margaret's turn. She stood slowly, heart pounding. Not from fear, but from restraint. This was her first real moment to speak directly to the judge, to the room, to the record. Your Honor, she began, voice steady, I am not a lawyer. I am a librarian. I don't speak in legal terms by habit. But I do speak in facts. And I know how to find them. She took a breath. For the past 8 months, I've researched every document tied to this land, court filings, tax records, historical maps, cemetery registries. I've found inconsistencies, missing notices, and most importantly, the absence of something the law requires, confirmation that my family was ever properly notified before our land was taken. She raised a slim folder. This land isn't just soil and wood. It holds my family's graves. It holds decades of work and memory. And while that may not carry legal weight in every courtroom, I believe this court is one where truth still matters. She sat. Silence followed. The judge gave a slow nod, then gestured to the clerk. Plaintiff, call your first witness. Margaret rose again, this time with practiced confidence. The plaintiff calls Gina Tran, Deputy Clerk of Woodrow County. A quiet stir ran through the gallery as Gina approached the stand and was sworn in. Her expression was composed but slightly tense. Margaret approached the podium. Ms. Tran, can you tell the court what your duties are regarding property notifications? I oversee the sending and recording of certified notices tied to tax liens, zoning applications, and abandonment declarations. And does the county retain proof of delivery for those notices? Yes. Or it's supposed to. We use a logbook system. Margaret nodded and held up Exhibit A, a photocopy of the 2003 logbook page. Can you confirm this is an official record from your office? Gina leaned forward. Yes. And what do you see under the name Margaret H. Hastings? N. Asterisk. No signature or confirmation. That means the notice was prepared but not successfully delivered. Is that a complete notice, legally speaking? Gina hesitated. No. The law requires proof of delivery. Margaret turned to the judge. Your Honor, I submit that the county's abandonment declaration was never properly executed, and as such, any acquisition that followed was based on a faulty premise. The defense objected, but Judge Greaves waved them off. She's establishing foundation. I'll allow it. Over the next hour, Margaret called 2 more witnesses, a retired county employee who had tried, unsuccessfully, to fix a clerical error in her father's tax payments, and a local historian who confirmed that the family cemetery had been in place for over 80 years. Each answer built the case, brick by brick, and each time she sat down, Liam looked at her with a kind of quiet awe, as if he couldn't quite believe how sharp, how methodical she had become. But the most revealing moment came just before recess, when Klein cross-examined Margaret directly. Miss Hastings, she said, voice measured, you speak of heritage, of memory. But you lived in town. You didn't maintain the land continuously. You didn't pay taxes in your name. You didn't file for ownership until after the development plans became public. Wouldn't you agree that this fight only started when there was something to lose? Margaret stood still. Yes, she said. Because before that, I didn't. No, I had already lost something. The courtroom was still. Judge Greaves called a recess. Margaret sat down, drained. The first battle was behind her, and it had gone well. But she knew Klein's questions were only the beginning. They would press harder, look for weakness. Still, as she glanced back toward the gallery, where Janet, 2 of her old students, and even Ray, her cousin, now sat, she felt stronger, because the truth wasn't just in the documents. It was in her voice, and that, she knew, was finally being heard. The next morning, Margaret woke before sunrise, unable to sleep. Her mind was already in the courtroom, scanning arguments, anticipating questions, hearing again the way Klein had emphasized the words, only started when there was something to lose. It hadn't rattled her then, but now, in the quiet of her kitchen with the coffee still brewing, she could feel the sting. Her binder sat on the table, marked up and dog-eared, filled with exhibits that had once felt like shields. Today, though, she had no idea what she'd be defending against. The defense would begin presenting their case, and while Margaret had been meticulous in her research, she couldn't prepare for what they might dig up from places she didn't even know to look. She arrived at the courthouse early again. Liam was already waiting inside, looking tense. They filed a new exhibit late last night, he said as she joined him at the defense table. I only just saw it. What is it? He slid the folder across. Inside was a single scanned document, one Margaret hadn't seen before. It was a letter, dated 2005, written by her father. It was addressed to the county assessor's office and read, to whom it may concern, I no longer intend to maintain the family land off Deerwood Lane. Please remove me from further correspondence, as I will not be pursuing inheritance or ownership. Consider this matter closed. Thomas C. Hastings. Margaret stared at it, stunned. This can't be right. Liam looked at her carefully. Do you recognize the signature? She nodded slowly. It's his. But I never knew this letter existed. The courtroom doors opened. People were taking their seats. Judge Greaves entered a few minutes later, and the trial resumed with calm precision. Vanessa Klein stood. The defense calls Mr. Everett Saul, assistant records officer at the Woodrow County Assessor's office. A thin man in his 60s took the stand and was sworn in. He adjusted his glasses, glancing nervously around the courtroom. Mr. Saul, Klein began, can you confirm that this letter, she held up the document, was received and logged by your office in 2005? Yes, he said. I located it in a filing drawer while preparing material for this trial. And in your professional opinion, is this document authentic? Yes. We have the original envelope and a matching signature on file. Klein turned to the court. This letter indicates that the plaintiff's father, Thomas Hastings, voluntarily surrendered his interest in the property nearly 2 decades ago. The county acted based on this statement and ceased sending notices, which would explain the lack of delivery Margaret Hastings is now contesting. She looked at the judge, then back to the witness. Does this letter affect the county's classification of the land as abandoned? It likely informed it, yes, Saul replied. A letter like this is unusual but legally relevant. Margaret felt the weight of every eye in the room. She rose for cross-examination, slowly, binder still in hand though she barely looked at it. Mr. Saul, she said, voice calm but taut, was this letter ever copied to me? Was I ever notified that my father had written it? No, ma'am. Not that I'm aware. So the county took his statement to mean that no one in the family wanted the land? It appears so. She nodded once, then continued. Did the county attempt to confirm that he had legal authority to surrender the property rights of other heirs? He hesitated. I don't believe we investigated that question at the time. Margaret stepped forward slightly. My father wasn't the sole heir. He had a sister. I have cousins. I myself was listed in the county census, living in the same district. No one thought to confirm whether we had a claim. No, ma'am. She paused. Then walked to the defense table, retrieved a folder, and handed it to the clerk. I'm submitting Exhibit 12, a notarized affidavit from my Aunt Ruth Hastings, confirming that she was never contacted, never informed of this letter, and never consented to surrender the property. Judge Greaves accepted it and nodded. Margaret turned back to Saul. Let me ask you one more question. If a landowner walks into your office and says he no longer wants to maintain his property, is that legally binding? No, ma'am. It's not. A formal abandonment of claim would require a quitclaim deed or court documentation. A letter like this is informative, but not decisive. Margaret gave a quiet thank you and Saturday the judge called a 10-minute recess. She walked briskly out into the hallway, Liam behind her. I didn't know, she said, voice low. He never told me. Liam nodded. I believe you. I thought he died holding on to it. I thought I was finishing something he started. Liam's voice was gentle. You still are. That letter didn't settle ownership. It just shows. He gave up. She looked at him, eyes wet but dry of tears. I wish he had told me why. They returned to the courtroom, and the defense continued its case. A zoning officer testified that Denner's development plan had met all county requirements. An appraiser valued the land at over $3 million once rezoned, making it clear why the company had fought so hard to keep it, but nothing struck as sharply as the letter. It lingered in the courtroom air like smoke, subtle but stinging. Margaret knew the damage it could do, not legally, perhaps, but emotionally. To the judge. To the jury if the case reached that point. It added doubt. And doubt was the one thing she couldn't afford. That night, Margaret sat on her porch, staring into the dark, holding the copy of her father's letter in her lap. She remembered him sitting in that very chair 20 years ago, silent as ever, watching the wind move through the trees. He hadn't been weak. He had been tired. Tired of fighting a system that kept changing the rules. Tired of being dismissed. She could understand that now. But she couldn't follow him down that path. He had laid it down, but she had picked it back up. She stared out toward the hills, the distant trees still silhouetted under the stars, and said, aloud to no one, you stopped fighting. I won't. The courtroom was quiet again, but this time for a different reason. After the defense presented her father's letter, momentum had shifted. Margaret could feel it, not in any formal ruling, not in the judge's behavior, but in the subtle tension that settled over the room, as if her case had been bruised, not broken. The jurors hadn't been called yet. But Judge Greaves would decide if one was necessary. Everything rested on the next few days. Margaret spent the evening after the cross-examination at the library, long after closing hours, surrounded by stacks of dusty ledgers and rolled parchment. Her badge as head archivist still gave her full access, and for the first time since the trial began, she felt like a librarian again, not a litigant, not a symbol. Just someone looking for something long forgotten. Liam sat across from her, sipping a vending machine soda and scanning a digitized map from 1892. This land has changed hands twice before the Hastings deed, he said. But here, look at this language is unusual. He zoomed in and pointed to a section of the old document, brittle with age and filled with looping cursive. Margaret leaned closer. Her eyes traced the inked words slowly. Parcel hereby conveyed in perpetuity to the Hastings family line, conditional upon unbroken generational occupation or stewardship, with primary burial grounds to remain protected and exempt from commercial encroachment. She blinked. That's not a regular deed clause, Liam said. It's a conditional title, she whispered. We weren't just owners. We were stewards. Liam sat up straighter. If that language was embedded in the original deed, then it predates the county's authority to reclassify the land under abandonment. They never had jurisdiction to declare it abandoned without accounting for this clause. Margaret stared at the scan, her heart pounding. How do we prove it still applies? If we can find that clause mirrored in the final transfer to your great-grandfather, if it was included in the 1897 formal deed, we can argue that the original intent of the title was never extinguished. Especially if the county failed to note that during the rezoning process. Margaret stood up suddenly. We need to find the original deed. It's not in the county system, Liam said. I already checked. She was already pulling on her jacket. Then it's in the church records. St. Agnes Chapel sat 3 miles outside of Woodrow, half buried in kudzu and forgotten by nearly everyone but the wind. It had once served the farming community on the southern ridge, and the Hastings family had worshipped there for 4 generations. Margaret hadn't stepped foot inside since her grandmother's funeral. Now, just past midnight, she stood at its heavy oak doors. With a flashlight in one hand and a ring of borrowed keys from the Historical Society in the other, the interior smelled of mildew and cedar. Dust motes floated in the moonlight. The altar was bare, but the side room, once used as a vestry, held the real treasure, rows of filing cabinets untouched for decades. Liam stood beside her, both of them wearing gloves now, flipping through yellowed folders and handwritten registries. Here, she said suddenly, pulling out a cracked folder marked Hastings, 1897, 1930. Inside, tucked between 2 brittle birth certificates and a marriage license, was a copy of the deed. The ink had faded, but the clause was there, in formal legal script, recorded by hand and notarized by a man named Elias Cobb. Conditional in perpetuity, contingent on familial care and preservation of interned kin upon said parcel. Liam let out a slow breath. They missed this. The county missed this. No, Margaret said. They ignored it. Or didn't bother to look. Back at her kitchen table before sunrise, they scanned and preserved every page, then organized it into a formal evidentiary packet. Margaret didn't sleep. 89 a.m., she returned to court and filed a supplemental motion for consideration. Motion to recognize conditional title clause and assert protective covenant against rezoning. It landed on Judge Greaves's desk within the hour. He read it slowly. Then again. His brow furrowed. The clerk handed him the scanned copy of the deed, the original language highlighted in 2 places. Where did you find this? He asked, eyes fixed on Margaret. In church records, she said. Filed when the chapel served as both spiritual and civic record keeper for Southern Woodrow. The county digitized only what it deemed legally relevant. This was never transferred. Greaves looked toward the defense table. Klein was already flipping through the motion, lips pressed into a line. Denner leaned back in his seat, his jaw rigid. This clause, the judge said, would require a new evidentiary review. If valid, it could fundamentally alter the county's basis for abandonment. He looked at Margaret again. You're requesting a protective stay? Yes, Your Honor. To prevent any preemptive action on the site until this clause is fully reviewed. Greaves paused. Motion granted. Effective immediately. We'll reconvene in 48 hours for legal argument on the clause's enforceability. A low murmur rippled through the gallery. Margaret sat down slowly, trying to quiet the pounding in her chest. For the first time, Denner looked at her, not through her, not past her. At her. This was no longer a sentimental defense. It was legal armor. That evening, as rain pattered softly against her windows, Margaret placed the original scanned deed into its own folder. She labeled it in block letters, Hastings title, conditional clause. She left it on the table and poured herself a cup of tea, her hands finally still. Her father may have walked away, but her great-grandfather had left her something more powerful than memory. He had left her the law. By the time Margaret stepped into the courthouse for the clause hearing, the quiet courtroom drama had become something else entirely, a public spectacle. The pews in the gallery were nearly full, not just with neighbors this time, but with reporters, law students, and one man Margaret vaguely recognized from the State Historic Commission. Her story had spread beyond Woodrow, but Margaret didn't walk differently. Her back was straight, her steps steady. The weight of her tote bag, now loaded with carefully prepared exhibits, copies of the original 1897 deed, affidavits from historical archivists, and a statement from the Regional Preservation Office, was familiar on her shoulder. Heavy, but grounding. Liam walked beside her, quiet and sharp-eyed. "They're going to come hard at this," he said. "If they can't break the clause itself, they'll attack its relevance, its legality under current zoning codes, and its applicability to you." "I know," Margaret replied. "But the words are still there. And they haven't changed in over 100 years." They took their places as Judge Greaves entered and called the court to order. "We are here to determine the legitimacy and enforceability of the clause presented in the Hastings Deed of 1897, he said. "Both parties have submitted filings. Let's begin with the plaintiff." Margaret rose, hands steady on the podium. "Your Honor, this clause, recorded in 1897 and preserved in the vestry archives of St. Agnes Chapel, was a legally binding condition of land transfer from Ezekiel Walling to Jonathan Hastings, my great-grandfather. The language is explicit: the land is to remain in the Hastings family, provided generational stewardship continues and that the family burial grounds remain protected." She paused, then continued, "This wasn't symbolic. It was legal. And it was honored, until the county, unaware or uninterested in the original deed, declared the property abandoned without ever referencing this clause. The failure to consider it nullifies their claim to proper process." She presented a certified statement from the Regional Preservation Office, a preliminary recommendation for historical protection status based on the clause and the confirmed burial site. "We're not asking to reclaim what isn't ours," she concluded. "We're asking for the law to acknowledge what already was." Judge Greaves nodded and gestured to the defense. Vanessa Klein stood. She was crisp, direct, less aggressive than usual, but no less determined. "Your Honor," she began, "the clause in question, while historically relevant, is legally outdated. Conditional titles of this kind have limited enforceability under modern real estate law, particularly when they predate zoning ordinances, inheritance reform statutes, and municipal control over abandoned land." She picked up a stack of documents. "We argue that the clause was functionally extinguished by failure of continuous occupation and a lack of probate assertion following Mr. Thomas Hastings's passing. The county acted within its rights under abandonment law." Margaret stiffened. Klein turned to her with subtle precision. "Furthermore, Ms. Hastings did not formally record this clause with the county at any time prior to this dispute. Had she truly been acting as a steward, as the clause demands, wouldn't that responsibility have included legal preservation of its terms?" Margaret stood, interrupting. "Objection, Your Honor. That's argument disguised as cross." Judge Greaves raised a hand. "Sustained. Keep it to legal argument, Ms. Klein." Klein backed off, but only slightly. "Then allow me to point out that the Hastings Clause, while noble, is not self-renewing. The law requires active maintenance of rights. The plaintiff's inaction for nearly a decade should be seen as forfeiture, regardless of original intent." Silence settled over the room as Judge Greaves reviewed both parties' filings. He turned page after page, lips tight, eyes scanning, tapping a pen against the bench in a slow, deliberate rhythm. After nearly 10 minutes, he looked up. "The clause is real. Its authenticity is not in dispute. The issue is whether it still carries legal weight." He paused, "And in that regard, both sides have made compelling arguments. The county failed to consider this clause when initiating the abandonment process. However, the clause's enforceability, given modern statutes, remains ambiguous." Margaret's heart sank. "But ambiguity is not nullification," Greaves added. He looked up, directly at Margaret. "This court finds that the original conditional clause warrants full judicial review. We will proceed to trial on all claims, inheritance, abandonment, and deed enforcement. The protective stay on the property remains in effect until a verdict is reached." The gavel struck once. Margaret exhaled slowly. She hadn't won, not yet, but she hadn't lost either. And more importantly, the clause would be heard in full. The crowd began to stir as the judge exited. Vanessa Klein turned toward Denner, whispering. His jaw was clenched, unmoving. The pressure was on, and he knew it. Margaret turned to Liam. "They're going to try something. Something bigger." "I know," he said. "But so are we." Back at the library that evening, Margaret sat alone in the archives room, staring at the copy of the 1897 deed under a reading lamp. The language was delicate, almost poetic. In perpetuity, stewardship of lineage, preservation of those interred, these weren't just legal terms. They were promises. A contract not just between families, but between generations. Her father hadn't protected it. Maybe he couldn't. But she could. She picked up a pen and wrote a list. Witnesses for final hearing, expert on land title law, local historian testimony, final affidavit from Aunt Ruth, final statement, personal, concise, resolute. She tore the page from her notepad and tucked it inside the front cover of her binder. The trial's final phase was coming. And this time, the past would speak not as nostalgia, but as law. The final day of trial dawned heavy with anticipation. It was the first truly cold morning of fall in Woodrow, and the courthouse steps were slick with dew. Margaret stood at the top of them, coat drawn tightly around her, eyes scanning the horizon. Where mist clung to the hills like breath on glass, today, it would end. The gallery filled early. There were no more empty seats. Local press, law students from 3 counties, elderly residents who'd known the Hastings name since it meant something. Even Margaret's estranged cousin Ray was there again, this time sitting up front, jaw tight, elbows on knees. At the defense table, Charles Denner looked grayer than before. His usual confidence was dulled by weeks of pressure. Vanessa Klein maintained her composure, but her legal pad was covered in notes written far more hastily than usual. Margaret sat beside Liam, binder closed now. The pages inside had been read, marked, cited, challenged, and defended. She knew every word by heart. Judge Greaves entered. The bailiff called the room to order. We're here to hear closing arguments in Hastings versus Denner and West Properties. Each side will have 30 minutes. Plaintiff may proceed. Margaret rose. Not with drama. Just with purpose. She walked to the podium slowly, feeling every step. Your Honor, she began, this case has never been about stopping development. It's about ensuring that history doesn't get erased because someone decided it was inconvenient. She looked directly at Greaves. I've shown that the county failed to properly notify my family before declaring our land abandoned. I've shown that there is a binding clause in the original deed, one that limits what can be done with that land. That clause has never been revoked, overwritten, or legally removed. It has simply been ignored. She took a breath. Her voice stayed even, but most of all, I've tried to show that this isn't just about property. It's about responsibility. Stewardship. A promise made in 1897 that someone would look after this land, generation after generation. That someone turned out to be me. She paused for just a moment, then nodded to the judge and returned to her seat. Klein stood next. Your Honor, she said, the plaintiff is a compelling speaker. Her story is moving. But this courtroom is not for stories, it is for law. And the law says that property unclaimed, untaxed, and unoccupied for over a decade may be reclassified and repurposed. She tapped her finger once against the desk. The clause she cites is over a century old, buried in a vestry cabinet. It was not registered with the county. It was not upheld through continued occupation or tax payments. Its spirit may still resonate, but the law must deal with facts, not intentions. She looked at Greaves. We ask that the court honor the legal process that has already taken place, and permit this land to fulfill its future potential. Saturday the room was still. Greaves folded his hands. The court will recess for 1 hour while I review final documentation and prepare a ruling. The gallery emptied in a hush. Margaret didn't leave the room. She sat still, eyes on the seal above the bench. Liam leaned toward her. No matter what happens, he said, you made them answer for everything. She nodded, quietly. An hour later, the court reconvened. Judge Greaves returned, eyes weary, voice firm. This case has tested not only the limits of real estate law, but the court's role in honoring legal memory, the promises embedded in documents long before any of us were born. He paused. After thorough review of the deed, the abandonment proceedings, and the evidence presented, the court finds as follows. 1. The county did not meet its full obligation to notify all heirs of record prior to the abandonment ruling. 2. The conditional clause contained in the 1897 deed, while outdated in format, was never legally extinguished. 3. This court recognizes the clause as enforceable under the preservation statute cited by the plaintiff. 4. Any development proposal that violates this clause is prohibited. He looked at Margaret now. Accordingly, ownership of the land reverts to the surviving Hastings heirs, with you, Ms. Margaret Hastings, named legal steward and trustee of the parcel, pending updated filings. This court orders a formal stay on any construction permits, and recognizes the family cemetery as protected by state historical preservation law. The gavel struck once. It was over. A beat of silence passed, and then the room breathed. Not an outburst. Just air returning to lungs. Margaret sat frozen, barely hearing Liam whisper, you did it. She stood slowly, turned, and met Denner's eyes for the last time. His stare wasn't angry. It was empty. The look of someone who realized, too late, that the land he tried to buy already belonged to something deeper outside the courthouse. Steps were bathed in light. A cluster of reporters gathered, but Margaret didn't stop. She stepped past them, past the murmurs, past the questions. She walked until she reached the edge of town. Then kept going. By early afternoon, she was back at the property. She stood alone, near the old fence line, beneath the massive oak that had once shaded her father's pickup. The house was still half collapsed. The grass still high. The cemetery still quiet, but the ground felt different, not because it was safe now, but because it had been heard. She knelt near the small stone marked 1923, and pressed her hand to the soil. "You're home," she whispered. "And I'm still here."